Hello, I'm Jim Turk, the director of the Center for Free Expression, and I'd like to welcome you to tonight's panel. We're going to be taking a close look at how Canada's federal government is planning to deal with the serious issue of foreign interference. But before we begin, I want to acknowledge that the Center for Free Expression is on land which is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabeg, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis. And also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit and the Williams Treaties with multiple Mississauga and Chippewa bands. I would also like to thank our co-sponsors for tonight's discussion, and they are the BC Civil Liberties Association, the International Civil Liberties Monitoring Group, and PEN Canada. We're grateful for your support. Foreign interference has rightly become a major issue for Canadians. In May, the federal government introduced legislation, which it named Bill C-70, the Countering Foreign Interference Act. Despite the importance of this issue, the government pushed the legislation through the House of Commons and the Senate so rapidly, there was no chance for any serious study, detailed consideration, and sober second thought, so important to an issue of this significance. The new law raises serious civil liberties concerns in its plans for a foreign influence registry, new powers for CSIS, and significant changes to our criminal code and our Security of Information Act. Tonight, we're going to look at the new law and what it may mean for our country's ability to address the serious issue of foreign interference while preserving our fundamental rights to freedom of expression, assembly, and association, vital rights in any democracy. Nick Robinson, our featured guest this evening, is a senior legal advisor at the International Center for Not-for-Profit Law. Nick's research and expertise center on how foreign influence laws can undermine civil society, the right to protest, and liberalism and civic space. He regularly contributes to both media outlets and academic publications and has testified before the US Congress as an expert witness. He is an author of a recent report entitled Foreign Influence Registration Laws, an analysis and responses. Welcome, Nick.
Thanks for having me, Jim.
Our pleasure. In conversation with Nick will be Tim McSorley. Tim is the national coordinator of the International Civil Liberties Monitoring Group. Tim's work focuses on the impact of government national security and anti-terrorism measures on civil liberties, including issues around privacy, freedom of expression and association, and racial, religious, and political profiling. Welcome, Tim.
Thanks, Jim. Great to be here.
So for the audience, the format for tonight's discussion will be about a 45-minute conversation between Nick and Tim, reviewing a lot of these issues and going into some of the things Tim has written about that Nick has written about and as Tim has taken up through the ICLMG. After about 45 to 50 minutes, we'll turn to the audience for questions that you may have. So if you look at the bottom of your screen, you'll see a Q&A button. It's a button that has a little square with a question mark in the middle of it. The chat function for for this version of Zoom doesn't function, but the Q&A button is the way in which you could ask questions. And we really encourage you, as you're listening to Nick and Tim in their conversation, and questions come to mind that you'd like to ask one or both of them, please write down the question when you think of it. And then when Tim turns to the audience for their questions, he'll ask Ange Holmes, the coordinator of the center, who's monitoring the questions as they come in, to read out the first question. Then Nick and he will answer it and then go to the second question. So we really are looking forward to the questions that arise in your minds as you listen to this discussion, or questions you have more generally about foreign influence or interference legislation. So with that, I'll turn it over to the two of you. Looking forward to your discussion.
Great. Thanks a lot, Jim. It's great to be here. Great to see you, Nick. And yeah, thanks so much to the Center for Free Expression for organizing this and for inviting me to be in conversation with Nick tonight. It's really a pleasure. I'm really looking forward to kind of digging into these really important issues that Jim really laid out so well. Before we get to the first kind of set of questions, I just wanted to give a bit of context, share a bit of context, Nick, about the situation that we've seen in Canada, what led to Bill C-70 being introduced and passed this past spring, and kind of maybe lay some groundwork, some ideas around the context for what we're going to be talking about tonight. I think it's really important to put in the frame, as Jim did, as these are important issues around foreign interference. We've seen real impacts, and we'll talk about that too. But for our organization in particular, we're concerned about the impact of transnational repression of human rights defenders, of activists, and there is a real issue that we've heard around people in Canada with family living in other countries, of other nationalities, who may face either repercussions here or repercussions, or their family members facing repercussions and even threats and intimidation, jail time abroad. So we take this really seriously, but we also have to look at it in the terms of what exactly is foreign interference, and where did this whole debate come from. And I think for our context here in Canada, we can even look back, as we often do, to what's been happening in the United States, and we'll talk about that a little bit more. But back to 2016, when there were allegations of Russian foreign interference in the U.S. elections, and Donald Trump's role in that, and that we're seeing echoes of right now. And that led to people asking more and more questions here about whether or not this was a concern for Canada. What should we be doing? Are we doing anything? And the government responded, and there were some investigations, and they reacted to it. There were more reports from national security agencies. The government stood up some task force and even a critical incident response unit for during elections. And that kind of lasted from 2016 to 2022, and then we saw a real explosion in coverage. And this really came from some media coverage and explosive media stories about allegations of interference by the Chinese government, the government of China, in Canadian elections in 2019 and 2021, based on a series of leaks from intelligence and national security agencies. And these were shared and caused a lot of concern, but also a lot of questions about, where was this information coming from, who was doing the leaking, what were the motivations behind it, and especially for us at our organization working on the impacts of national security laws in general, we've seen a long history of, leaked information being shared for political reasons, and eventually being founded to, not necessarily be the whole truth, and sometimes even based on fabrications that suited, national security purposes. And so throughout the ensuing, 2 years since then, it's been a bit of a roller coaster in Canada, and especially around this issue, and especially with the heat of a minority government and a lot of partisan politics around what the government is doing about this. We saw, 2 national security reviews done. We saw a special rapporteur come and go, then a public inquiry that's still ongoing, continuing their study. And all along, we've seen concerns and questions around foreign interference. But at the end of the day, there's still a lot of questions around what evidence this is based on, what the impact has really been, how big is this problem, and what can we do about it? What should we be doing about it? And that led eventually to, as Jim said, the introduction of Bill C-70, which raised a lot of concerns. A lot of people supported it, but also raised a lot of concerns among our organization, a lot of people watching this from a civil liberties perspective, but also from a due process and legal perspective, because we saw the interim report of the Foreign Interference Commission come out on May 3rd, and all of a sudden new legislation was tabled on May 6th, very quickly. And questions arose about, is this in response to the report? How could they have, vetted this report in time to come up with these new regulations? And really what we saw in the report from our perspective was a piece of legislation that goes much too far, that serves to address a lot of issues that aren't related to foreign interference, but that national security agencies have been asking for a long time. But even specifically around foreign interference, that we believe, and others believe, go too far in and will likely cause a chill on freedom of expression, freedom of association, being able to work at an international level and in solidarity with international organizations. And we'll get into maybe some more, and we'll definitely get into some of the more, specific areas, but the two in particular are what Jim raised around the questions of new offenses for engaging in surreptitious, foreign interference activities, but then also the foreign interference registry and what that means in terms of organizations and individuals needing to sign up and be listed in this registry, what implications it could have for their involvement in the political process in Canada. And one of the big questions too is that even this bill has a lot of vagueness to it, a lot of questions of, what kind of powers this new commissioner who will be enforcing the registry will have. So, that's a lot. I wanted to set a bit of the context. It raises a lot of questions. I'm really hoping we can dig into a lot of it tonight, Nick. And especially because you've come out, this report is really excellent on foreign influence registration laws and civil society that you put out in earlier this year, and it really helps to frame some of the questions and concerns I think people may have around what this registry will mean for civil society and others in Canada. But first, I gave some of the context in Canada. In your report and other work you've done, I know you've looked at the broader context around, foreign interference laws in general. And so I was hoping that you could share a little bit about how you see the current context. And I guess, maybe not necessarily, but we know that the election is coming up pretty quickly in the United States, and to what degree you've seen this kind of playing out during the electoral process and season in the US as well.
Yeah, no, thank you, Tim. And thanks again to the Center for hosting. And I can't think of anybody better to be in conversation with on this than you, Tim. I know that you also testified on Bill C-70 before Parliament and raised many of these civil liberties concerns then. So watching this, you've been real expert in that I've been looking to on these issues in Canada. But maybe what I'll do is kind of just take a step back and look at this globally before we kind of dive back in around some of these questions and kind of some of these global experiences to create context for what we might be seeing going forward in Canada and what we might be concerned about. So just first up, so I'm a senior legal advisor at the International Center for Not-for-Profit Law. So we work in about 100 countries around the world to create a supportive legal environment for nonprofits, for activists, for social movements. And, over the last 20 years or so, we've seen this decline in democracy globally. And as we've seen this decline in democracy globally, we've also seen this restriction in civic space in many countries in which we work. And when I talk about civic space or civil society, I'm talking about nonprofits, I'm talking about activists, I'm talking about media. And one of the primary tools that we've seen that is used by governments to target civil society globally are these kinds of foreign influence laws. And I want to say up front, I want to echo what you said, Tim, is there's legitimate concerns about foreign influence, and those are real concerns. And we also work on those. We work with activists and nonprofits that have been targeted in the United States and in other countries by authoritarian governments. So we take that very seriously. But what we've seen is that many of these laws that are getting enacted are ineffective for addressing this problem. And they're also overbroad and vague. So very similar to, I think, what we're seeing some of the provisions in Canada. And so on the one hand, we have these authoritarian governments, really kind of starting with Russia back in 2012, that are enacting these foreign influence registration schemes with an explicit eye to target, surveil, and control civil society, and have used that as a tool to really decimate a lot of civil society globally in these countries. And I think it's important to understand, this is kind of out of the authoritarian toolkit, that it's very rare now for governments to go in and, physically harm activists in their office or that sort of thing, although that does happen. Instead, what we see more of is the use of these kinds of bureaucratic tools like foreign influence registration laws and saying you're not in compliance with this or you're not in compliance with this. We're going to launch an investigation. We're going to cut off your funding. We're going to shut you down. And it makes it much harder for the publics in these countries and even for the international community to react because governments can say, oh, it's a national security issue, right? You don't have any right to look at this, right? And so we see that kind of play out again and again. And so we've seen Russia, China enact similar kinds of controls on civil society. But we've also seen this in established democracies, particularly in the last few years, and as you pointed out, since 2016, with these allegations of foreign influence and Russian influence in the US presidential election. And so you saw the strengthening of enforcement of the Foreign Agent Registration Act in the United States, which is this much older 1938 Anti-Propaganda Act that I can talk about more later, which had really gone dormant for a number of decades. And the Justice Department decided to really start much more strictly enforcing this, but it's a very overbroad and vague act and has created a lot of confusion in the US civil society nonprofit community and the media. But we've also seen Australia and the United Kingdom enact foreign influence registration laws, and then Canada, obviously, this year. And I think they're trying to target this malign foreign influence, but we have concerns globally about these laws of just being overbroad and vague. And I think one of the things that I will compare this to is kind of what happened post 9/11, right? After 9/11, there was this legitimate concern about terrorism. No one was denying that terrorism was a real concern, but we saw the US and many other countries enact these really draconian, overbroad anti-terrorism laws that were then used in very undemocratic ways. And not only that, were then copied in other countries, in more authoritarian countries, that then could justify their laws by pointing to the US, by pointing to the UK and others, and saying, oh, we're just copying what they're doing. And we're seeing the same thing play out, where even, for example, some people might be aware there were protests earlier this year in the country of Georgia. And then and last year around a proposed foreign influence law. And the activists who were going out on the street, they were facing down water cannons. They were saying, don't pass this foreign influence registration law. It's a pro-Russia law. It's going to draw us into the Russian sphere of orbit. And the government pointed back and said, no, this is actually just based on the Foreign Agent Registration Act in the US. Other democracies do this, right? So we can do it too. What are you complaining about? Right? And so this has become a real kind of global fissure that Canada's entering into with its kind of own unique domestic political context, but is part of a wave that we're seeing globally.
Interesting. Yeah, no, thanks for that. And that's a really interesting comparison. I think a really apt one we've noticed too about the global war on terror and how in these moments of you know, not to overstate it, but of crisis or what is portrayed as a crisis, that we see you know, the governments bring in these overly broad laws, both out of maybe an abundance of caution, but also I think, you know, as we've been seeing right now, as a way to enact laws that security agencies and governments that maybe have wanted to bring in, but haven't had the opportunity to do so until this, you know, this kind of opening presents itself. Not to be too on the head about it, or you know, not going into conspiracy theories, but just we've seen that this can happen. But that overall, what we see is that in these moments, there's that opportunity for overly broad laws and for you know, fear and kind of the heat of the moment. And as we saw back then, and I think right now too, fear of the other, fear of you know, rising ideas of nationalism and xenophobia can really have a powerful impact on how these laws play out. I want to maybe if we can dig a little bit more into what you found in your report. You know, what we saw in Canada was that Bill C-70 passed incredibly quickly. Again, it brought in changes to the Canadian Security Intelligence Service Act, to sabotage laws, which the government admitted wasn't even related to foreign interference, but also created these new foreign interference laws. And one of the things that we also noticed is that a lot of it has been left up to regulation that's going to come after the fact. We actually don't really know what are going to be the criteria for the kinds of information groups are going to have to provide to the new foreign influence commissioner, as they're being called, who that person will even be, and what the impacts of what some of those will be. So I was wondering if you could share a little bit more about how you've seen these registries and, and if possible, if other foreign interference and influence laws, how they've played out, and what, could we maybe be expecting to come about in Canada over the next year as this gets stood up?
Yeah, sure. So I think one of the things that comes out of the report, and we try to break down, is not only the similarities between these laws, but also the differences between these laws. And I do think that's important. Language matters in these laws, particularly when you're talking about how they should be targeted. So, for those who aren't familiar, many of these laws essentially require individuals or nonprofits or companies or others to register if they're acting on behalf of a foreign principal in a covered activity. And some might have some exemptions we can get into, but that's the general structure of these. And we see real differences on each of these vectors, right? So some of these laws for foreign principals will cover any foreigner. So that's like a Russian law, right? It's also the US law with the Foreign Agent Registration Act. You'll see covered activities be all over the place, from just any activity you're doing, you have to register, to political activities, but then query how you define political activities. And maybe we can get back into this in the Canadian example too, because the Canadian law really seems to cover a lot of potential advocacy that individuals and organizations could be doing. And then it's, if you're acting on behalf of somebody, what does that mean? And these laws define this in very different ways, often with vague language. And I think maybe you'll talk about this a bit more in the Canadian example, but this has been a real problem globally. What makes it that you're acting on behalf of somebody else, right? So for example, in the United States, under the Foreign Agent Registration Act, if you act at the request of a foreign principal, that creates an agency definition, or it meets the agency requirement. But what does that mean, right? To act at somebody's request? And that's generated, the Justice Department has released dozens and dozens of advisory opinions. There's lots of confusion about this. And what it's done is it's chilled beneficial political advocacy in the United States that I think nobody thought was a problem. It's also created a bunch of law firms that have sprouted up to advise nonprofits, companies, and others, right? I often like to call FARA like an employment scheme for law firms in DC because of the vagueness around the act. And we see this in other countries as well. I see law firms globally, right, putting out advice about all these laws and how to comply. And it gets more and more complicated because the law isn't very clear often. And so then there's regs, but then the regs aren't always clear. And then there's advisory opinions, and then there's court cases that might be coming up. So it just creates this whole kind of confusion, particularly when you just don't have, clear, bright lines in the law itself. And that's something that we've seen globally being a real problem, including in more authoritarian governments where, where there's any vagueness, right? The government's definitely going to use it against groups. But we've also seen this politicization of these laws in established democracies. So in the United States, I'll just kind of point out a couple examples and we can get into more. But even when the law first was enacted, it was used actually to go after Nazi propaganda in World War II. And I won't get into the history of that. And it was World War II, so they enacted this really broad law. Again, it was this moment of fear, right? And so everybody, rallied around it. But then after World War II, and this just goes to show once you enact the law, it lives with you, right? It can be used in other contexts. We hit the McCarthy era in the United States, right? Which was this fear about communism. And so the law was used to prosecute W. Du Bois, who is one of the major civil rights figures in the United States. Looks like Martin Luther King Jr., W.B. Du Bois, like there's just a handful in the constellation. And he was viewed as being too sympathetic with socialism or communism in the United States. And he was prosecuted for circulating a petition from a French nonprofit, right? That was an anti-war, anti-nuclear petition. Case went to trial, right? He was acquitted by a jury, but it really delegitimized him, right, for the rest of his life. He was already older, and his reputation never recovered in his lifetime. It was only after his death that his reputation came back. And then more recently, we've been seeing a whole host of congressional investigations based off of the Foreign Agent Registration Act. And it's important to keep in mind, once you have these laws on the books, they're not going to just be used, for example, by prosecutors. They're going to be used in the media, people casting aspersions on others, be used by members of parliament, or in our case, Congress, to write letters to organizations and others. And we've seen this particularly against environmental groups, and then now with the Palestine protests, of members of Congress, chairmen of committees, launching investigations into, are these groups, right? This kind of broad aspersion in violation of this act. Somebody better go and investigate. But the fear is, and I think, is that this is being done because of their political speech, and that people just don't like what they're saying, or one political party doesn't like what they're saying. So I think those are some of the concerns maybe to look out for in Canada.
Thanks. Yeah, no, that's really interesting, really helpful, and just raises a whole other host of, a kind of associate ideas. Again, this idea of, kind of labeling and casting aspersions, I think really speaks to the work that we've done around the war on terror, and how after 9/11, and I think in the context of the, protests in support of Palestinians right now, the easiness of throwing around labels of supporting terrorism or extremism, and being investigated based on those, vague kind of expanded allegations and overly broad laws, really kind of speaks again to what we're seeing with foreign interference issues. The same, and we can talk some more about it later, but so even before we had the Bill C-70 passed, we also saw here community organizations working in Chinese Canadian communities, in particular in Montreal, caught up in this idea that there are these foreign Chinese police stations. And there were some legitimate concerns around that, it appears, or we've been told. It's been very difficult to get clear information from the RCMP, but there's these two organizations in Montreal that haven't been charged with anything, continue to face investigation, but no actual allegations. And they're actually suing the federal police force right now for defamation, because they've seen cuts to funding, people being scared from the community come and partake in their language services and their social services, helping apply for government funds and government programs. Because they're worried that by simply stepping foot into these community organizations now, they'll be viewed as somehow supporting, foreign interference, when really there hasn't been any, there's these big allegations, but no actual concrete evidence or concrete information being shared about it. It's really, had a significant impact. And so, based on everything you're saying, I was hoping to share a little bit with you, a bit more about the specifics of the Canadian registry system that's being proposed. And maybe you can kind of comment a little bit on how it compares to some of those other systems that you've studied, and how it stacks up. So I think the important thing, like you said, is language. And so the proposal of the Canadian system is that what would trigger it is if an individual or an organization enters into an arrangement with a foreign entity, in order to, and the way it's defined here in the law, to carry out under the direction or in association with a foreign principal any of the following activities in relation to a political or governmental process in Canada. So that includes communicating with a public office holder, which includes politicians, but also their staff, other people in public office, at all levels of government, communicating or disseminating information, including on social media or by any other means, information that's related to the political or governmental process, which again is defined in very broad ways. Or finally, distributing money or items of value, or providing a service or the use of a facility. So giving concrete kind of materials or financial support. But what's interesting there is, again, as you said, the definitions. And so what is an arrangement? So if you enter into an arrangement with a foreign entity, what would that be considered? And so for the purposes of this law, An arrangement is acting for the under the direction of, which is pretty clear. You're being directed, told what to do, or in association with a foreign principal. And the in association with is something I hope we can dig into a little bit, because that's not defined in the law, and that's raising a lot of concerns, and has been one of the key areas of concern in this part of the act, and in other laws that were brought in. Because in association with doesn't necessarily mean that you're being told what to do, that you're acting for the benefit of a foreign entity, but rather you might be working together as peers on something where you equally share the same kind of interest, the same opinion, but simply because you're in association with a foreign principal, you would have to register. And then the other key definition, I think, is also the idea of this foreign principal. And again, from our perspective, I'd be interested to see how it stacks up again with what you've seen, is that the idea of a foreign principal is also very broad. And so it's defined as including a foreign economic entity, which is any entity that's either controlled in law or in fact, or substantially owned by a foreign state or a group of foreign states. And so here it raises concerns around foreign media outlets. Some like RT, Russia Today, have been in the news a lot and raised, a lot of legitimate concerns about their independence from the government. Others like Al Jazeera or BBC are also, state affiliated, state funded. Are they considered owned, substantively owned? Are they controlled in fact or in law? It raises a lot of questions. Same thing with academic institutions that may be government affiliated. And so there's this question of what is the breadth of who you can or can't work with. And then beyond that, it also includes any foreign entity, which is also an association of foreign governments. So it could be the United Nations, NATO, the Francophonie, or finally, any foreign power, which is a foreign state or a group that's recognized as controlling a certain, foreign area, whether or not they're the actual government. And can also include terrorist entities and others deemed to be terrorist entities. So we can see that there's this very broad use of language that we're not quite sure what it will mean at this point. And we've been told by the government to wait until the regulation process is done, until the new commissioner comes in, who will be running the process. And it's an independent commissioner, which is good to see. But it leaves a lot of questions around what some of the impacts will be. And maybe we can talk about some examples you've seen other places about whether or not it would fall under this, or concerns that we have here. But yeah, I was wondering if you could speak a little bit about how this compares to some of what you've seen in other jurisdictions, or does it raise any alarm bells for you? I know you've looked at the legislation too, and if there's anything else you want to highlight, that would be great.
No, thank you for that. And yeah, I think those are the provisions that I know you've zeroed in on. When I looked at the bill, they also kind of popped out at me as somebody who's not an expert in Canadian law, but has looked at a lot of these kinds of foreign influence registration schemes. And, I think first I'll give the credit where credit's due, in the sense that it's narrower than, for example, FARA on the foreign principal definition, right? Where you have these countries like the United States, which has created problems for Americans interacting with Canadians, where foreign principals include not just the Canadian government, but any individual in Canada, right? It could be my grandmother in Canada, right? Can be a foreign principal under the Act. And that's treated, with the same equivalence of the government of Saudi Arabia. And so there's been a narrowing there, but as you rightly point out, it creates all these challenges, right? Because it's not just a foreign government, but it seems to include potentially, and we'll see where if regulation or anything else clarifies this, but things like the University of Michigan or the University of California, or as you said, Al Jazeera or BBC. And these can raise real freedom of expression, academic freedom, free press issues. And we've seen this in different countries, and same for nonprofits also receiving foreign government money. So I'll use an example in the US that's public, so I can use, how it's had this chilling impact, but I know of others that are not as public, where the National Wildlife Federation, for example, received a grant from the Norwegian government to fight climate change, to work on multinational corporations' supply chains to make them more sustainable. And that included a lot of work in the global south. It also included working with US multinationals within the United States. And they were told by the Justice Department in the United States to register because they were receiving foreign money, right? Foreign government money to be working on, to engage in some sort of political advocacy. And so kind of query whether would be the same kind of trigger in Canada for a similar situated group. And NWF has written a letter and said, look, this had a real big impact because other foreign governments and other foreign donors now don't want to give us money anymore to work on climate change, which is one of the most pressing issues of our time, because they're worried about all of the administrative burden that goes into this, what it means, what is the connection between us, right? And so it creates a chilling impact not just on nonprofits who might engage in this activity, but also funders. We've also seen this, for example, with Australian universities, who, after the Australian Act was enacted back, I think it was in 2017, Parliament had a review of the Act and said, how is this Act doing? And the universities came forward, and at least some of their submissions went to somewhat to the effect of, this has been a very heavy compliance burden, right? Now, every time we're putting on a conference, every time we're trying to figure out research grants, tie-ups between an Australian researcher and an American researcher or a Canadian researcher. We have to send this out to legal, right? We have to make sure we're in compliance, see where there's any issues. Through all of this, we don't seem to have captured anything of concern, right, to the Australian government that was originally notified. We've also developed our own independent process that the Australian universities did on a kind of a risk-based assessment that was tailored to universities. And they said, there we've had much more success, right? But this kind of draconian national security one-size-fits-all approach just really isn't working for us, right? And has had this chilling impact. So I think, when you're looking at things like the foreign principal definition, and then this association, right? I've never come across this of language that this is so broad. Are we in association today? Is everyone listening, in on this conversation in association? And for one definition, yes, I was talking to an activist from the country of Georgia not long ago, and their law got enacted eventually over the opposition of protesters in the street, and he was looking around the world to see, are there better models that we could be using around the world? And he was like, oh, Canada just enacted one of these laws. And so he went and looked at the Canadian text, and he was like, what is this in an association? I can't propose this at all to my government, right? They would just go down and shut us all down. And this is the sort of thing, I think, as an outsider, that you'd want your lawmakers to be weighing in on these kind of critical things that can make or break kind of the civil liberties implications of the law.
Mm-hmm. Thanks. No, that's really helpful. And I think that's a really good point about this idea of in someone in Georgia, which is viewed as rightly or wrongly as having maybe less robust democratic protections than Canada does, and even they're balking at the language that we're seeing in Canada's in our new foreign influence registry. And just on that, another part of it is the scope of what's covered. So in terms of, I wanted to see what you thought also about in terms of the fact that any kind of communication on social media that kind of goes public, as you said, a webinar like this, and the fact that it isn't just specifically targeting a legislative, a member of parliament or something like that, but it could be putting out information to the public that would influence the development of a legislative proposal, the development or amendment of any policy or program. What kind of implications do you think that kind of language has?
Yeah, and again, we'll see how it plays out, but I think it's concerning because you could imagine very beneficial activities, right? Like a university, say, Toronto Metropolitan University wants to put on a panel with some experts from the United States on global pandemics, right? And talk about how governments should respond in the future to global pandemics and what were like the big lessons learned from COVID. And now there's a query, if one of those is coming from the University of Michigan or the University of California or elsewhere, well, they need to register under this act. What is the burden going to be in registering under this act? Will that deter that convening from even happening? So any knowledge, kind of beneficial knowledge that I think everybody in Canada, whether you agree or disagree with whatever the recommendations, we can all agree it would be better to have experts coming in and sharing their insights. And then you can make what you want of that. That's being shut down. And I think that's the important thing to remember. I think a lot of people are like, well, foreigners don't have rights, right, in terms of speech and expression. And to some extent, I think that might, we can have that debate, but the right actually is about Canadians to be able to hear from others, right, and associate with others, right? It's about Canadians' rights. And I think it's important to center that in these conversations, because I think sometimes it's like, well, what right does, a foreigner have come? It's about the right to be able to listen and to hear to those perspectives or to work in association with foreigners around common problems. And I think this is where, like a rights perspective can be really important in that, as you've mentioned already, like it's so easy to build up fear about the foreign, right? This kind of abstract notion of there's foreigners, they're out there, they're trying to undermine our democracy. And to that, I always say, yes, let's talk about specific threats and kind of address specific threats and think those through. But in that can cloud out the real costs that come with these, right? And if you look at, I don't care what democracy it is, I'm not an expert in Canadian history, but any democracy, I think if you look at like positive social change that has happened, whether that's empowering minority communities or the right of women to vote or, whatever, it's all about making sure we all have clean water to drink, right? These are cross-border movements that are operating across borders, and people are learning from each other to bring positive social change to the society and to the country that they live in. And so it's very easy, I think, to lose sight of that because it's more little interactions, right? They're not these big controversies and crises that come out in the news of, we have to respond to this in some ways. What we're losing is that texture of being able to engage with each other in interactions where we don't have fear, where we're not worried about what the law is going to be, if we're going to be investigated, if this is going to lead to something later. And I'd say in the United States, it used to be just like big international nonprofits, like the big environmental groups that knew about FAIR and had it in their mind. It's been in the last couple years that I've really heard from like grassroots activists and folks on the ground who are worried about the Foreign Agent Registration Act in the US being used against them. And that's because it's starting to get used in so many different ways. There's worries about politicization. And you can see it. There's this chilling that happens and this concern about engaging with people across borders and what that might mean. And it makes everyone smaller, right? And in a democracy, I think we're trying to make everyone bigger and everyone to have a bigger voice.
Thanks. Yeah, no, that's really helps to, set the context and the importance and the impacts of these, of these laws, and especially around, who gets to be heard, who do we get to work with, and this idea that so many movements are based on cross-border and transnational and international movements that, we need to be, keep that in mind when we're bringing in these kinds of laws. So, to look at it from the other side, so we've both said that, there is a problem around, that there are areas of problems with foreign interference that we need to be taking seriously. And, we've raised a lot of the concerns, but I could also see people raising the concern that, well, on the other side, we see people losing, being hindered in their freedom of expression and association by the, interference by foreign governments. That misinformation and disinformation that's coming as a result of these foreign interference, strategies, are actually hindering, democratic processes and democratic debate. And that, despite the consequences, maybe this is what we need in order to help protect our democratic systems. And so I was wondering just what you might respond in terms of, this question of, one of the things I guess we've seen here in Canada is that we're still not quite sure in some ways what the actual impacts of foreign interference have been, and whether or not these responses are measured, proportional or necessary. And you kind of talk about that, not kind of, but you talk about that very directly in your report, and in if you want to mention more details of the article that you just published, I think today or very recently, that kind of digs into this in more detail. And so what would you say, to someone who says, well, there may be an administrative burden on organizations, but then what are we going to do to actually address foreign interference? We can't just stand by and not take action.
Yeah, no, and thank you for that. And that is something that I hear not just in Canada, but in many countries, right? I think a lot of democracies are trying to struggle with this, and I think many are struggling in good faith. And they understand some of the civil liberties concerns. I think sometimes they diminish those civil liberties concerns, and they don't. It's hard for them to appreciate the cost to democracy that might come with some of these laws that we're seeing. And I'd say a couple of things. I'd say one is, we've seen this sort of response where there's been this turn to these foreign influence registration laws in a strange way because the US had enacted this Foreign Agent Registration Act back in 1938, that when countries, and there's been, controversies that have come up in Australia about Chinese foreign interference as well, and in the UK, and the EU is considering a defense of democracy package right now. That includes a proposal around a foreign influence registry, but there's a real division within Europe right now about whether this is a good idea or not. And I think, it reminds me sometime of that I think this line came from Yes Minister, Yes Prime Minister, the old UK sitcom, where, there's a crisis and it's like, we have to do something, this is something, right? And so I'll just say, we have to do something, this is something. Right. And so it's like, we have to do something. What can we do? Well, this foreign influence registration system is something. Right. And at least it shows we're doing something. Right. And the most important thing to do is to show we're doing something. But I think that misses the point. Right. Like, is this actually targeted to the goal? And so, yeah, I've written about this also in a law review article that came out recently where, I think solutions need to be really problem oriented. Like, what is the problem you're trying to address? Right. And this is, something I alluded to with the Australian experience is if your concern is about foreign interference in the university context, right? Maybe adopt something that is university specific. There, it seems to be regulations that are coming out of the universities themselves, right? To address a real problem that had been coming up, but in a much more targeted, nuanced way that was sensitive to all of the complications of like the modern global university, right? And how you think about that. Maybe your problem is around intimidation, right? But intimidation is already illegal, right? So maybe that's a law enforcement problem, right? Maybe that's about making sure law enforcement is equipped to address this problem in a targeted way. In the US, there's just been a couple controversies, like the mayor of New York City, right, was arrested for accepting illegal campaign contributions from Turkey, or charged with this. I don't know if he's guilty or not. I'm not going to speak to those facts. But there's campaign finance laws, right, that can address those kinds of questions around foreign election interference, right? Or bribery that has come out, the Qatargate scandal in the EU, right? Where you can have much more, maybe it's about foreign government lobbying, right? So you're thinking about responses to foreign government lobbying. But what I see again and again in these registries is everybody's trying to put everything into the registry. It's going to fix this problem. It's going to fix this problem. It's going to fix this problem. And it ends up not being very good at fixing many of the problems that people are trying to put in it. And then creating both these civil liberties concerns, but also these just tremendous administrative burdens, and it costs a lot of money to run these, right? You got to set them up. You're basically setting up a surveillance state over part of your civil society and economy. And everyone has to report in now. They got to know the rules. You set up all the law firms, right? You're setting up this really big complex that is not just government, but multiple parts of this. Everybody's going out to their general legal counsel trying to figure this out. So I'd say, yes, this is a problem. But I think there is also learning that's happening across countries to have much more targeted responses. That's a short and brief answer.
Yeah, no, that's a great answer. Thanks, Nick. Yeah, no, that's that's I think really speaks to the concern. I think balances of that. There are issues, but it needs to be targeted. It needs to have some kind of approach and like proportional approach. And I think you mentioned that in that law review article that you put out, the example I mentioned earlier about these so-called Chinese police stations, that the RCMP, even before Bill C-70 was enacted, they came out and said, success, we've shut down all the foreign police Chinese foreign police agencies in Canada, and they were able to do it without the need for foreign interference legislation. So I think that, yeah, kind of a domestic, local kind of example of exactly what you're talking about. Something we haven't touched on, and I think it plays a big role in this question of the chill on free expression, how people may censor themselves before even knowing whether or not they need to register, and that's the penalties that can be associated with either a failure to register, or deciding not to register, or even improperly registering. So I want to share a bit again about what we see in the Canadian law, and maybe if you can build off that onto what you've seen in other places. So in the Canadian context, for the registry itself, there could be a finding of a violation, which is a more minor violation. Somebody would be sent a letter outlining the violation, and then they would be given a certain amount of time, I believe it's 30 days, to either respond and challenge the finding of the commissioner that they were in violation of either not registering or failing to register, because even though they're engaging in these activities, or improperly registering. And then within those 60 days, you can either challenge it, or at the end, you may be levied with an administrative monetary penalty. And it doesn't lay out in the bill what that penalty would be. That's, again, left to regulations that we'll see at sometime in the coming months. Then beyond that, it creates two different offenses. One, again, an offense of failure to register, and then another where it would have to be proven that you've actually decided actively not to register. So essentially to act surreptitiously and continue acting in secret. And for both of those, it could be either as a summary charge, and then you're liable to up to $200,000 in fines and or 2 years less a day in prison. Or if you're indicted on that, on a much more serious charge, you could face a fine of up to $5 million or up to 5 years in prison. Which in itself is considerable and concerning, especially what if you don't know that you're acting in association, or that association is in breach of one of the kind of very broad categories of communication and democratic processes. But on top of that, there's been changes to what's called the Security of Information Act in Canada, where they've added in new foreign interference offenses. And one of those would essentially be that if you commit any indictable offense, so including not registering, in association with a foreign entity, then you could be liable to life in prison. Or if you're engaging surreptitiously in interfering in the democratic process, again, defined very broadly, including governments, but also educational institutions and others, you could also be found to be charged and face life imprisonment. And so the concern would be that you may fail to register and be charged under this, but that could also trigger these even harsher penalties if it's believed that either you acted surreptitiously, which maybe you're acting with a foreign entity, but you don't believe you should be registering, and so you don't. But it's still surreptitious, you're keeping it to yourself, or simply committing any indictable offense at all under any piece of Canadian legislation. And because it's in association or for the benefit of a foreign entity, then you may face life imprisonment. So those to us seem, very harsh penalties and could lead people. And as you mentioned earlier, one of the concerns we've had is around this question of people protesting in the streets in support of Palestinian human rights, and the real breadth and continuous allegations that who's funding these people, they're working in association with terrorist entities or foreign governments, they must be getting money from there. And it could trigger an investigation, may not lead to a charge, but just the fear that it could raise that maybe, you could be found guilty of one of these offenses, or even just kind of labeled with them, could really have an impact. So I was curious, it's very specific, but what you think of that, and how it might line up with some of what you've seen in your research as well.
Yeah, and I appreciate how you pointed out how these can interact with other parts of the law. And suddenly, it might just seem on its face, you do a quick reading, like, oh, this is just an administrative fine, right? That if I don't register, where if it's read with another part of the law, it seems like you could be facing up to life in jail, which I've never seen anything, right? That, I've looked at these laws, including in pretty authoritarian regimes, where they're not placing those kinds of criminal, they're placing criminal penalties, um, but nothing of that significance where you're facing such a severe and seemingly like disproportionate penalty. And I could see a situation where, there's a potential like good faith, I just didn't know, but there's also a situation where maybe you're engaging in that academic conference that I mentioned, and it's somebody from like the University of Michigan coming, and you're like, well, I don't think this is what the Canadian government's really concerned about. I know that I probably should register under the letter of the law, but that's just going to create a lot of burdens. I'm having a really busy time at work. This isn't what they're going after. Then suddenly COVID becomes a hot topic, right? There's like investigations, everyone's kind of looking into things. Maybe you suddenly you're in a more politicized position than you ever thought you were going to be, as an expert in pandemics. And suddenly you could be facing life in jail, right? Like that's a very significant and seemingly highly disproportionate penalty. And we've also seen this in the US where, some of the FARA charges that have been brought have been not just for violating FARA, willfully violating the act, which can lead to a 5-year criminal penalty in the United States, but conspiring to. And I'm not an expert in Canadian law to know how it can also interact with these other provisions that are often already on the books, right? That
Right.
you don't even have to be doing it yourself, right? But you're just part of a collective of people and you kind of know what's going on. You're taking a step together, to further that from going further. And prosecutors love this, right? This is part of the reason, even though when national security folks might know this isn't the best, most targeted fit for the problem, they're like, well, I know who the bad actors are, and I want the broadest umbrella I can get, right? And I want the most draconian laws that I can bring against people. Because then I can bring this case. I don't know how that works in Canada, but in the US, we've had this real problem where prosecutors will make the maximum charges that are available, right? In an attempt to get whoever they're going after to plea to a lesser charge, right? Because then you don't have to go to trial, but you can really scare people, right? You can scare people who are just trying to express their free opinion. They didn't know, or maybe they should have known, right? They do something that seems like shouldn't be facing these sorts of severe penalties, and now they're facing these really draconian punishments. And so we've been seeing that in the United States, and I think that's something really to look out for. And then the other part that you also reference, which is a real big fear here, and we've seen some of, which is using these to then justify significant investigations, right, against folks in civil society. So, I mentioned some examples in the US that were affecting people in the progressive community, like climate change, Palestine protesters. But we've also seen this, in the conservative media in the United States, where there was a conservative social media activist, journalist, who had his home raided, right, by the FBI, claiming that he might be violating FARA. They went through his papers, right? They went through his hard drive. I don't know. There isn't charges in this case, so we don't know, right? But a lot of people in the right wing in the United States got really upset about this, right? Because this blogger also had views where he thought that, for example, there should be a ceasefire between Ukraine and Russia, right? That, it has a more kind of a pro-Russia perspective that isn't aligned with the policy of the Democrats that are in power, but is in line with some Republicans and conservatives in the United States, and a feeling that he was being targeted based on viewpoint discrimination. And so you can see how this can be used in a lot of different contexts. And again, your home can get raided, right, under these kinds of national security laws. And it can have this real chilling effect and just send a message to everybody else of like, watch what you're saying out there.
Right. Yeah. No, I think that's a really good point. I think it's important to remember, yeah, we tend to point towards maybe more impacts on progressive issues, but it's important to note, I think here too that there was a lot of people who work on more, have more conservative leanings, and who would also be caught up in these laws. There was the occupation of Parliament Hill 2 years ago during COVID, 3 years ago now during COVID, where I have my own very strong opinions around the legitimacy of what they were protesting for, but there were a lot of accusations thrown around that they were that they were supported by foreign funding, and that it was a foreign influence kind of operation, that didn't turn out to be true either. And so it's important that there's responses to actions that that cause a risk to public health and safety, and in the case in Ottawa, that really resulted in violence towards residents of the city. But at the same time, it needs to be based on what's actually happening, and not on these kind of broad assertions and insinuations, and that that end up not being based on facts or evidence. Yeah. So no, thanks for bringing that up. I think maybe now would be a good time to see if there's questions. We could talk all night, but it's a good time to see what questions we may have from folks watching the webinar tonight. Just as a reminder, you can put your questions in the Q&A box. You can find that at the bottom of your Zoom screen, and we'll be checking on those. So. Ange, would you be able to share with me maybe the first question that we have tonight?
Yeah, and as Tim just said, you can use the Q&A button to ask a question if you would like. The first question is from Richard, and Richard says, the first report of Justice Hogue mentions in the first few pages that it has not investigated the extent to which the conclusions reached by CSIS were reasonable given the information collected. Hogue sought some guidance from CSIS, but otherwise took it for granted. Given that previous inquiries on Maher Arar and others found that CSIS and the RCMP exaggerated or made false claims about them, should we not conclude that the Hogue inquiry has already discredited itself by not considering this problem?
I think
I'll let
that's
you take that one, Tim.
Yeah, Nick. Yeah, yeah, you want me? Yeah, I can start that one, and maybe I can see if there's some aspects you want to tackle. So I think it's a really good. Thanks for sharing, and I think that's a really good question. I've looked at the Hogue report as well, and certainly there's a lot of concerns around the reliance in general that we've seen over the last several years on intelligence reports from CSIS and other national security agencies that we know, and they've been clear, and they've said on the stand at the Hogue Commission too, that intelligence isn't necessarily fact. It's a collection of information that they use to analyze and put forward, possibilities of what's happening, and they, can rate that based on reliability and credibility of where the information is coming from, and what's being said, and the kinds of data they're being provided. But it really does raise concerns around the credibility of any findings. Personally, I think the Hogue inquiry and the Hogue Commission has been more thoughtful and circumspect, in looking at what CSIS is saying than some of the other inquiries, and what we've and also what we've seen in the media, certainly. But I think you're right. So Nick, I don't know if the Maher Arar inquiry says anything to you, but essentially, and this was something that our organization was heavily involved in, but in the early 2000s, there was a Canadian man, Maher Arar, who was stopped while traveling and renditioned by by the CIA to Syria, where he was interrogated and tortured over several months, based on faulty information provided by Canadian national security agencies. Maher Arar wasn't the only one. There were also Abdul Al-Maki, Muya Nuruddin, and Ahmed Almaty, who were also the subject of a follow-up inquiry. And in all those cases, we saw that leaked intelligence was used to kind of create this idea of a threat that didn't really exist, that either intelligence officials jumped the gun and believed they had enough information, or, has come to light, were in some cases making up information. So a journalist at a conference we organized spoke about how they were promised by an RCMP agent that they had documented evidence of Maher Arar participating in a terrorist training camp in Afghanistan. And the journalist said, let me see it. And they wouldn't show it to them. And so the journalist never ran with that story. And then it turned out that that evidence didn't actually exist. But other journalists weren't as circumspect. Others were willing to rely on information without seeing the basis for it. And we saw the case of another individual, Abdul Al-Maki, who it was said that he had a map of terrorist points of interest on Parliament Hill. And turned out he was a truck driver, and he had a map that simply had, the different buildings on Parliament Hill marked off to ease, so that delivery people could easily make their deliveries and navigate their way around Parliament Hill. But because he was Muslim and because it was in his hands and because of the mosque he went to, it was presented to the media as a terrorist map. And so I think we have real reason right now to be to remain questioning and remain suspicious until we see what comes out of the final inquiry report and see what's rendered public before we can really say that whether or not there's credibility to a lot of the allegations are being made. I'm not sure I would go so far as to say that the Hogue inquiry has already lost all credibility, but I think that they need to really show in their final report, especially when it comes to recommendations around policy, to what degree they're basing it on evidence, and to what degree it's being guided by intelligence, and why we should trust that. Because right now, and especially in terms of Bill C-70, what's being presented doesn't match up with what the what the repercussions and what the responses have been. Yeah.
And maybe I'll just quickly add that this will come to a surprise to few, but we see this kind of same story play out in so many other democracies, including the United States and Europe. And I think it goes to, and I've seen this particularly with these foreign influence registries, where when you think about the incentive structure of those kind of working on national security issues, it's to catch that incident, right? That might be a crisis or lead to some negative impact. And that's understandable that that's their incentive structure, but not when, right, it leads to spreading inaccurate information. And also it means, and I was glad to hear that there was an independent commissioner that's being set up over this registration process, because in the United States, we've had this real problem that the Justice Department, their incentive structure with the regulations for the Foreign Agent Registration Act is to keep all the definitions as broad as possible, right? So that they can always go and use it and prosecute it later, because you make your career prosecuting cases successfully, not protecting people's civil liberties. As hard as, as unfortunate to say that, right? Through having more targeted regulations. And so I think as members of the public and as people who are concerned about civil liberties, we need to be kind of focused on that incentive structure and not always take everything we hear for granted, right? And be skeptical of many of the things we're hearing just because other people have different incentives that are, pushing them to kind of more extreme, less targeted positions and not rights respecting positions where you're always thinking about, is this a targeted solution? Is this a proportionate solution? Is it addressing an actual problem that's going to be actually addressed with this potential solution?
Mm-hmm. Thanks. Then we have another question, but that actually reminds me of something that I wanted to ask you about. And that's in terms of, oh, wait, I think it's slipping my mind. But this idea of, what was it? Sorry, you know what? Let's go to the next question, and then it'll come back to me. But it was something that
sure.
you said that triggered it. But yeah, Ange, do we have another question for?
Yeah. The next question is from Aaron. And Aaron says, I think we understand the risks of overzealous enforcement, but what are the solutions that can deal with the People's Republic of China or Russia-maligned influence? Geopolitics has changed. China is a peer threat to the West, democratic allies, while Russia has invaded Ukraine and threatens Europe as the largest war since World War II.
Thanks, Ange. Nick, do you want to take a?
Yeah, sure. I can start, and I'll kind of. I think we had some earlier points on this about kind of targeted responses and thinking, but yeah, I think this is a real issue, and I think part of the reason we're seeing the rise of these acts is the broader geopolitics that this questioner points to about concerns about kind of this dividing world between China and Russia, and the U.S., Canada, Europe, or at least parts of Europe. And some of the other democracies. And how are we going to respond to this situation? And obviously, this has been a real live issue in the United States as well, where the government, for example, just shut down around the election a disinformation campaign, or I shouldn't say disinformation campaign, that there was RT, and the Russians were funding some right-wing social media folks in order to kind of elevate certain views that they thought were divisive to US society. And we've seen this tactic before. And the people in the United States didn't even know that the money that they were receiving was from the Russian government. And so they weren't charged, but there were sanctions put onto the Russian government and to RT for doing what was essentially kind of like a spy operation. And there were also charges brought against them. And I do think, you have to think about what are the different tools, right? And I think sanctions can be a really blunt tool, right? Obviously, you're elevating. But if if you go back to, the World War II example, I don't think anyone in the United States was expecting that we were just going to let, the Nazi German government operate freely within the United States, but we had declared war, right? A whole set of things got triggered because of that. And I think it's about having these like targeted and tailored responses. And I know I sound like a little bit of a broken record here, but I think it's so important because it's so easy to get, but what about this and the fear, and they're doing this and this and this and this. We have to do everything. And at least let's get this registration thing, and maybe that will do something, right? But I think that's just really fundamentally the wrong way of thinking about it. That you really want to come in with solutions. And this has been an experience that, FARA has not been great, and the Australian Foreign Influence Act, at rooting out, say, Chinese foreign interference, right? Because a lot of it's clandestine, people aren't registering, right? This just isn't a tool fit for purpose but it is causing all these concerns within civil society in the United States, right? And it's employing a bunch of lawyers that we probably don't need to be paying to be doing this. And so I think, again, serious problem, and democracies can learn from each other, right? I do think that there's valuable lessons that can be learned for more targeted, nuanced responses, and then enforcing the law, when people actually, have threats of violence against them, other things like that, that require action.
Great, thanks, Nick. No, I think that really covers it. And yeah, and that point that I was thinking of was this question, and you raised it there around how if there are individuals who really don't want to be caught, who are really engaging in surreptitious activity, they're not going to sign up for a registry that's listed publicly anyways. They're going to try to find ways around it. So there's that whole question of effectiveness. So yeah, thanks for raising that. Ange, do you have any more questions for us? I think there's a few more from the audience.
Yep, there is. The next one, at the outset, Jim claimed that the federal government rushed Bill C-70 through Parliament in a way that prevented any serious examination of the bill. Tim, do you know how many weeks of hearings the House of Commons committee spent considering the bill, and how many weeks the Senate committee spent on the bill before passing it?
Yeah, no, I do, and definitely agree completely with what Jim said. So the bill was introduced May 6th. It received royal assent by June 20th. So in about a month and a half, a little less, it went from being introduced in Parliament and getting first reading to going all the way through the House of Commons and Senate, which is incredibly fast. In total, I believe it got about 6 days. Well, less, because it was over a period of 6 sitting days, but I don't think there were 6 sessions. Probably 4 or 5 in the House of at the House Committee. That's the House of Commons Committee that studied it. And then for the Senate, again, it was maybe less than a week of study at the actual Senate committee. But overall, it was very, very short. It was less than 2 weeks total in the actual committee study phase, and very little time when it came to third reading in either the House of Commons or at the Senate. We came about after the passage of the first Anti-Terrorism Act, and that was introduced in mid-October and passed by the end of December. And so it was a longer bill, but took a few weeks more. And at that point, it was viewed as being incredibly rushed, taking 2.5 months to pass pass through, or maybe just 2 months to pass through the House and Senate. This one took even less. So that the study was incredibly rushed. We were told on multiple occasions at both committee hearings that if only we had more time, we could consider this some more. But we need to do this now, and so we're not going to bring any substantial amendments. We're unable to. And a big part of that was because of the specter of a possible snap election because of the minority government, and the fact that people wanted these laws in place before the next election. And on one hand, that's reasonable because it's supposed to engage and help prevent interference in the elections. But on the other hand, when we're thinking about rules to manage elections and rules that have such wide-ranging implications, we can't really expect to rush them through and then fix it later if it doesn't work out. And that's what we're in a position to have to do now. There's provisions for reviews of the foreign influence registry after the next election. It has to be done within a year. Within several years, there needs to be a review of all the provisions of Bill C-70. But we often don't see those reviews happen, or if they do happen, it's a report put together by the government. Maybe a few witnesses appear if it's actually held in committee, but sometimes it's not. And there are suggestions, but the government has no impetus to actually act on those. And so it often doesn't lead to significant changes to a piece of legislation when we have this after the fact review. So Jim was right about the rush, and that rush we think will have serious implications down the road in terms of how the bill is implemented and its impacts. Yeah, Nick, do you have anything you want to add? Maybe no? Okay. Ange, any more questions?
Yeah, the next question. Nick, you discussed the range of countries enacting foreign influence laws, from authoritarian countries like Russia to genuine democracies like the US. Would you be able to comment on how Canada's new law compared to those in other democracies?
Yeah, so I would say that Canada's law in some ways is more similar to the UK or Australia in the sense of that, the definition of foreign government and foreign principle. Australia also has a somewhat broader version. The UK has a narrower version than the Canadian version. I'd say this language around, again, association, I've never heard, right? Neither the UK, the Australians, the US have that language, right? And I think that, as has been repeated on this, raised a lot of red flags, and I'm not quite sure where it came from, because one of the things we do see across democracies, particularly the advanced democracies, is they're borrowing from each other, right? We have a report that we did some time ago called Farah's Double Life Abroad, and it actually points mostly to mostly authoritarian governments that have pointed to the US and to Farah to justify their own legislation. But when Australia started a working group on this, they looked at Farah in the United States. I know Canada also looked at Farah in the US. I know the EU with the Defense of Democracy package looked at the US. They rejected certain aspects of the US in part because it's a really bad law, as we're discovering in the United States, and it's caused a lot of problems. And I think there's been some attempts to target it more. But again, the incentive structure is just to have this breadth, right? This kind of this national security view. And in the UK, I know they initially proposed some wider definitions, including around foreign principal, and it was because of active pushback by civil society that it narrowed. I know the initial Australian version was much more close to fair in the US, but civil society pushed back and was able to successfully narrow it down, because it's like, wait, this is going to capture all sorts of things that we don't want to be capturing. So I'd say there's some unique provisions, and that the other part that Tim was talking about with these just incredibly draconian penalties, right? Like I haven't seen anything like that. And, the US was kind of high with FAIR with 5 years. The EU with the Defense of Democracy package, they're considering like administrative penalties, right? So the way that this can be read with other law, I think, is quite concerning. So I don't know if that's helpful. So, it's similar but different. And I think those differences are important, particularly where they're raising these kinds of civil liberties concerns.
Thanks, Nick. And I know we're getting close to 8:30. I don't know if there's more questions, or if maybe we can combine a couple if there's a few more.
We just have one more question. So, and this one actually is for you, Tim, again. And the question is, what do you see to be the most troubling changes the new law makes to our criminal code?
Thanks. Yeah, no, that's a really good question. So the bill actually only made one change to the criminal code, but it's a significant change. And it actually changed the sabotage laws in Canada. So up until now, sabotage, I have to get this right because I'm not an expert on this particular area, but it was mainly restricted to acts that would interfere with military installations and foreign military installations in Canada. The bill, though, has now expanded the definition of sabotage to include interference with a range of essential services or infrastructures. And it's very wide-ranging, includes provision of healthcare, of food services. I believe energy is on there as well. I'd have to, I don't have it in front of me, so I'd have to look it up to find it specifically. But essentially what it does is it creates a much broader provision for sabotage that we and others, including the Canadian Civil Liberties Association, has really raised as well in their brief, raising concerns about C-70, which could clearly encompass legitimate acts of protest and of dissent. So I believe there's an exception in there, maybe for work stoppages. So for labor, strikes and other labor actions. But unlike other parts of Canadian law, there's no exception, for example, for engaging in protests, engaging in artistic actions. And so, for example, individuals who have been protesting against war for a long time have conducted activities outside of weapons manufacturers. And under the definition, it could be viewed that those are considered essential infrastructure. Others, for example, Indigenous land defenders and their allies have a long history of taking action by blocking railways, by holding protests on highways, by obstructing logging roads and access to mines. And based on these new sabotage laws, it's very possible that those kinds of actions would also be caught up as a criminal activity. Beyond, already there's already laws around, vandalism and around trespass and all kinds of things that have already been used to criminalize those kinds of legitimate protests. And so the idea of bringing in these new sabotage laws and changing the criminal code to expand sabotage laws, and the government to admit that it actually has nothing to do with foreign interference, but they saw this as a good opportunity to do so while we're bringing in foreign interference laws, is really just beyond the pale and is really I think should raise everyone's concerns about how governments use instances of crisis and concern and heightened security awareness that to bring in laws that otherwise would never pass. So there's also changes to the Security of Information Act that I mentioned. Those aren't under the criminal code, but are very similar to criminal provisions. And As I said, those are the ones that if you're acting surreptitiously in order to engage in foreign interference activities for the benefit under the direction of or in association with a foreign entity, you can face severe penalties, including life in prison. I won't go into all those now, but that's another kind of parallel there. It's not under the criminal code, but brings some very similar penalties to what you may expect to see in criminal code provisions, and that we hadn't seen in the Security of Information Act before, which its origins is really just to protect against espionage, against the sharing of government secrets and confidential information, but not to bring in these very broad offenses for interfering with democratic processes or acting in association with a foreign entity. So that was the last question. Then Nick, I'd just like to ask you if you have any kind of final thoughts you'd like to share. One thing, we've talked a lot about the difficulties of these laws, and I know I've been speaking with colleagues who worked on C-70 and it passed so quickly. And there seems to be such a groundswell in support of doing something, as you said, you have to do something around foreign interference. That can feel very hard right now to kind of keep the momentum going, to push back against a law that's already passed, and to make sure that at least, not necessarily bring in best practices, but, maybe engage in some harm reduction, making a little bit less, a little less worse than it is. So do you have any, closing thoughts and maybe any advice based on, what you've seen that we can, take as we move forward with this?
Yeah, no, certainly. And I appreciate everyone, like yourself, who's being vigilant about this and pushing back on these laws, both when they're being considered, but now that it's enacted, I think a lot of groups find themselves in this situation. And there's kind of two fronts. One, I won't spend too much time on. One is like, now groups have to figure out how to be compliant, right? Activists, nonprofits, others, right? And have to figure out the law, and there's going to have to be resources that go to that so that people aren't afraid, right? So that they've now heard about this foreign interference law, they're not quite sure how it's going to affect them. And you want to make sure that it's not chilling speech, it's not chilling all this good activity that's going on out there. And so there's going to, having a focus on that. But I'd say the other part is to be vigilant about, these laws and push for clearer definitions, more targeted definitions. I know you mentioned these opportunities that are going to come up, both kind of in the regulatory process and then reviewing the law later, to make sure, like what will in association mean, right? And I think it will mean in large part what Canadians push it to mean, right? And we see this in country after country. And that if it's just kind of the momentum, as you're talking about the momentum of this national security moment and these concerns that are out there, it's going to probably end up being broader than anybody would want in terms of kind of civil liberties concerns, right? And what we've seen again and again is where these laws are better targeted so we can better protect everyone in the country who's, engaging in activism and democratic discourse like we want them to be, that it's only when people organize together and push back that we get these, more targeted acts. And that's also through, and I don't know enough about the Canadian system, but I'll just reference it here, through litigation, right? So the Hungarian law, foreign influence law, was struck down by the European Court of Justice, the European Court of Human Rights, struck down the Russian foreign influence law after they left the European Court of Human Rights, but still. And, in the US, there's, talks of challenging at least certain provisions of the Foreign Agent Registration Act that are overbroad and are causing all sorts of headaches for civil society. So whether it's through, providing comment, writing pieces in the media, thinking about litigation strategies, thinking about compliance strategies, there's a lot to be done to make sure that this bill doesn't have some of the negative consequences that we've unfortunately seen in other countries, including not just authoritarian countries, but also established democracies.
Thanks, Nick. That's really helpful and gives that kind of boost of hope of what we can do next. And thanks for tonight. I've really appreciated being in conversation with you and for you sharing your wealth of knowledge. I hope everyone listening has found just as interesting as I have. And greatly appreciate your openness and the wealth of information you were able to share tonight.
Thank you. It was I really enjoyed it as well.
Thanks.
And
So yeah, maybe I'll pass it back over to Jim to close things out for tonight. And yeah, thanks again, everybody.
Well, I want to thank you, Nick, and you, Tim, both for a really engaging and thoughtful and informative discussion of a difficult issue. And we, as you were suggesting, we're going to have to look very closely at what's been passed and how we can moderate some of the excesses within the bill, either through regulation or through political advocacy or through litigation strategies. I also want to thank the audience for joining us. I hope you found it as informative and engaging as I did. A video recording of this conversation between Tim and Nick will be posted on the CFE website tomorrow. And along with it will be some additional readings and resources if you want to dig into the issue a bit more. You can find that at our website, which is CFE for Center for Free Expression, cfe.torontomu.ca. You'll also find there our variety of past events and discussions, some of which have been about foreign interference, as well as notices of upcoming ones. So I want to thank everyone for joining us tonight, and especially to those of you in the audience and to Nick and Tim. Thank you so much.
Thanks, Jim.